Well, tonight, Justice Gertrude Torkornoo files fresh processes to halt her removal proceedings. Her last-ditch attempt as she bears her teeth at those calling for her to resign, insisting she stays and fights.
Was a due lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of a due lodge.
Now we have details as the embattled Chief Justice reviews fresh moves at the Committee of Inquiry aimed at frustrating her. The latest being that the committee unilaterally says they are doing a litigation, not an inquiry. We also bring you a swift response from government denying any political agenda against the Chief Justice. Well, this is Top Story brought to you always by Telecel, connecting energies. Now, tonight, the embattled Chief Justice Gertrude Torkornoo has now turned to the High Court in a dramatic legal move to halt the process to remove her from office, describing the proceedings against her as deeply flawed and unconstitutional. The Chief Justice says she's left with no choice but to fight back, both in court and in public. Now, Michael Ashley will be joining. He was there and has just returned from this news conference by the Chief Justice. But the Chief Justice has been talking about the choice of venue, which was key in the matter of judges. And she says that venue was chosen to intimidate her. Listen.
And then the work of the committee is being conducted in a cordoned high security zone on Castle Drive, Osu, when all Article 146 proceedings since 1993 have been held in facilities of the judicial service. It is hard not to reach the conclusion that the choice of venue against the backdrop of secrecy of proceedings is intended to intimidate me and to prevent any citizen of Ghana from knowing how the proceedings are being conducted. The Edu Lodge facility that the hearings are being conducted in featured very prominently in the planning of the murder of judges on June 30th, 1981. And this can be read about in the special investigative report on that terrible event in our nation's history. It will be recalled that there was a Major Samakwa, a military officer who was killed with the 3 High Court justices, who was the director of human resource of GIHOC. He was my uncle and my guardian when I entered the University of Ghana in September 1980. I was also living with him at the time he was abducted and murdered. Was a Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of a Edu Lodge.
Well, Michael Ashley was at this news conference where the CJ addressed the issues and joins me in studio. Michael, a sitting Chief Justice is taking legal action against the very process meant to remove her. And she says that she's been forced to do this. What reason did she give?
Well, Ray, she gave 4 reasons, and I'll walk you through some of those. She says that the first reason is that the removal process that she's involved in as Chief Justice is historic. That's the first one. The second reason, she says this, for making this statement is that though she's in the process alone, its ripple effects go far beyond her as a person, and that she thinks that there's a need to then come and speak to some of the specific issues that have been in the media. Some of them just whispered. Some of them also said boldly out there. Thirdly, she says the reason for this statement is that in order to address the troubling violations of the constitution and legality of the proceedings that had become obvious from the beginning of the process. So that's why she started this procedure, or to come to the public and speak. And then the final and fourth reason for this statement is that she has heard on several occasions from loved ones even, and persons who care, and persons who may not know her beyond public duties, that who are asking her to consider quietly resigning. And she's responded to that boldly, saying that she'd rather stay and fight what she says is an injustice against the person.
Because if she resigns, she will be okaying the process that is flawed.
Yes.
And she doesn't want to do that. Now, let's talk through her concerns with the process and what she calls unfair treatment, which she says she's been subjected to.
Well, one of the main reasons she raises is that at the committee level that is supposed to be investigating or looking through the allegations and putting some questions to her, she says that she's been refused and some documentation. They've not provided her with the petitions or a proper outline of the charges, making it impossible for her to mount a full defense. She also says her legal counsel one time was sidelined during the first day of the proceedings, and she's been denied basic courtesies, including being barred from having a family member with her during the hearings. The hearings, she notes, are taking place in a high security zone away from the usual judicial facilities, which she believes was deliberately chosen to intimidate her. And this place, what we are talking about, is the Do Lodge, where she says that even the high, when you get inside, the search that is done on her body alone, she feels violates her personal space.
Well, let's now talk about the petitions and her responses to them. She sought to, let us in on the responses she provided to the petitions that were given her.
So, Brace, we'll take some of the petitions as we have. We know that there were three major petitions against it. The first one, which we know was filed somewhere on the 14th of February 2025. This was filed by the Shining Stars of Ghana. Some of the things that made two major concerns, or they had raised two major issues. One on misbehavior, and then another on her incompetence, for which they think that she should be relieved of her duty. Now, on misbehavior, they accuse the CG of breaching Article 144 of the Constitution by writing to former President Nana Addo Dankwa Akufo-Addo on May 30th, 2024, recommending some new appointments to the Supreme Court. They thought that was not in her mandate, and that definitely is a breach of her Constitution or the laws that govern the position that she occupies. Again, on incompetence, they allege the CJ were presiding over a case brought by the then majority leader, Lezen Afenyo Markin, challenging the ruling by the Speaker of Parliament, violated the same principles of natural justice she was asked to assess. So in that, they were asking John Dramani Mahama to remove her from office. There was another petition filed by ACP Ayamga Yakubu Makogo, that also claimed that the Chief Justice unilaterally ordered the person's arrest and removed from court whilst a case was going on. The person described the arrest as capricious, unreasonable, and without justification. And they thought that based on that, CJ Justice Torkornoo should be removed from office. And then the final one, which came somewhere around 17th of March 2025, they accused the CJ of misappropriating over 261,000 Ghana cedis in public funds in 2023 for personal international trips with her husband, Mr. Francis Kofi Torkornoo, who, by the way, was there, and her two daughters were also there, Adam and Sarah, were both with her. That particular petition also alleged that she also allocated 75,000 Ghana cedis for a separate trip to Tanzania and failed to properly account for $14,000 as interest. She's responded to all of these, and if you sum it up above all, she says that these allegations are not don't make or do not have merit enough to be considered as grounds for her removal. Individually, she's explained that there were circumstances like the arrest from court. The person that was removed from the courtroom, she said the person at the time was making noise and was forced to actually cause the person's removal and not arrest. Again, on the money issue, she says that these are things that is a paper trail. You can easily check. On the money for traveling, the $14,000 interest, she says she actually returned more than half of that money back to the accountants that gave it to her. And that also has paper trail that is easily traceable. So these are some of the responses she's been giving to these three petitions in particular, Brace.
But then she talks about the fact that the committee is denying her copies of the petition seeking her removal. Let's listen to what she said at this particular news conference.
At this Article 146 hearing, no rules provided by law to regulate the fairness of hearings and trials in this country are being followed. As we all know, when a citizen is summoned before a court or any administrative or disciplinary committee, it is the duty of the committee or court to give the citizen a copy of the complaint that they are presiding over. You cannot be summoned without a writ, a petition, or a complaint. It is also the duty of that committee or court or tribunal to give copies of all documents that have been filed with them before the hearing is started. How does anyone defend themselves without a copy of the complaint that they have been summoned to come and answer to? This Article 146 committee has refused to give me copies of the petitions that His Excellency the President gave to them. They refused to give me copies, a copy of the prima facie determination that His Excellency the President is supposed to have given to them. They claim that they know that the President sent me copies on 27th March of the petition on 27th March 2025. And so they do not need to show me what the President gave to them. They also claim to have copies of the responses that I gave to the President, but they will not provide the petitioners with copies of my responses.
Well, Papani, I mean, the Chief Justice also talks about the fight not just being a legal battle.
Well, Brace, so so this answer will be in twofold. One, on what the effect of what she's feeling emotionally and mentally, the torture that she's been subjected to. And at some point in the speech, she went almost away from the official stuff and sort of gave us an impression of what she's been subjected to outside of even the committee hearings and outside of the former city. She tells us that it will be best. She says some people told her that, CJ, it would be best if you just retired or resign rather than subject yourself to all these ill-motivated processes. She says she's also received, and that's where she reviews what exactly has been done on her person. She received threats and vowed threats to the effect that if she fails to resign or voluntarily retire, she'll be made to suffer some harm. Okay. And at that point, even you could feel the tension. I was trying to look for the faces of her family that she had come in the company with to see what exactly this meant for her, and sort of added even that this is not just to her person. These are things that people around her have even been subjected to.
What next from her?
So we're expecting that she's filed for judicial review at the High Court and says that she's prepared to pursue every legal avenue available. She's made it clear she won't resign. Now, despite threats and the pressure, for her, this is more than just personal survival. She sees this fight as a defense for the judiciary, from which she calls a dangerous precedent if it goes through.
Ladies and gentlemen, it is this total absence of compliance with all known rules of fair hearing that has caused my lawyers to file applications for judicial review in the High Court to declare all the proceedings void. Because the clear danger is that through this flagrant violation of CI 47 and the darkness of the current proceedings being held in camera behind the walls of a Lodge, my lawyers and I can come to the end of the proceedings. The evidence will show that every one of those allegations in the petitions that were given to me on 27th March is unfounded and untrue. And yet, the committee can dig up some allegation from whatever documents they claim to be having from the President, which they have not shown to me, and purport to enter a recommendation for my removal on that basis. Allow me to say that this is totally unknown in the rule of law in this country. If it was lawful, I would have no reason to alert the nation of the dangers they represent. It is the violations of law that have forced me to bring these matters out in the light of day.
Well, the government has offered a swift response to these, statement from the Chief Justice. Felix Ofosu-Kwakye is the Minister of State in charge of government communication.
As yet, nobody has been able to ascribe any known verifiable constitutional breach to the president in the way that he has handled this particular matter. From the very first steps in this matter, the president has kept fidelity to the Constitution and has respected the spirit and letter of the Constitution. Everything he has done has been by the book. That is why all those who have commented on the matter, including her ladyship, the Chief Justice, have been unable to point to any specific provision under Article 146 that the president has been in breach of. Second, in terms of confidentiality, the president has acted strictly in accordance with the Constitution. At no point in time has the presidency put out anything in any way, shape, or form that remotely resembles any of the contents of the petition. And the only communication that has gone out on this matter have been about the steps that the president has taken in accordance with the 1992 Constitution, Article 146 to be precise. 3, her ladyship, the Chief Justice, all but insinuated that there was some political agenda at play to oust her, and that this whole process is a result of same. Let me place on record, without fear of contradiction, and let me be clear that no such political agenda exists. His Excellency the President took an oath to which he was incidentally sworn by her ladyship, the Chief Justice herself. And in that oath, he swore to abide by the 1992 Constitution. He is enjoined to act a particular way when he receives petitions of the sort that he has received. And that is all that His Excellency has done. He has had no choice in the matter. The president cannot say that he has a view about how things should be done, and therefore, if petitions have come, he will fail to act. If he did that, he himself would be in breach of the Constitution, and therefore, he has been enjoined to act as any responsible leader or president of the Republic of Ghana would be required to do, as stipulated by the 1992 Constitution. The fourth point is also that we cannot have a sacred cow mentality in the way that we handle state affairs. Every single public official, from the president to the speaker, to the Chief Justice, to Supreme Court judges, to ministers, to all public office holders, are bound by the provisions of Ghanaian law. Indeed, it was the former Australian Prime Minister, Kevin Rudd, who once said that when you join the game, you play by the rules. So no public official is allowed to raise him or herself above the laws of Ghana. It does not matter how sensitive your position is. Once Ghanaian law dictates that certain processes be undertaken in respect of some alleged misconduct, the rules must come to play. And that is the only guiding principle that President Mahama has operated by in all of this. So any claim, any inference, any innuendo, any imputation of a political motive to the president in respect of these processes are unfounded, they are false, and cannot be allowed to stand. And I wish to place that on record. As yet, absolutely no evidence of same has been furnished in any way, shape, or form. And therefore, I am minded to strongly reject that effort. Unfortunately, her ladyship, the Chief Justice herself, has added to this commentary, which initially was the tone of elements of the opposition. And it is deeply regrettable that this should happen when the president has been above board and conducted himself in strict compliance with the Constitution of Ghana. The other point that I wish to also place on record is that the attempts to link the dastardly killings of some Supreme Court judges and a military officer to this case are most disingenuous. To begin with, this government and President Mahama have nothing to do with the killing of any judge. Second, there's absolutely no nexus between the petitions that have been brought and that unfortunate incident in our past.
That's still top story. Let me bring in Inusa Fuseni. He is a lawyer and former roads minister. Grateful to you, sir, for joining us here. Now, she lays the background as to what regulates the Commission of Inquiry like this. But she then says that on the 15th of May, the committee indicated that it will not conduct the hearing not as an inquiry, as directed by Article 1467, but as a regular litigation. Is there something all wrong with it?
What is wrong with it? So the committee, there are no guidance rules and procedure for the committee. So the committee will set up its own procedure in hearing the petition. And so, and that was the procedure they set up.
Well, she provides that on the statute books of Ghana, a constitutional instrument regulating the work of all commissions or committees of inquiry. And she says that is the Commission of Inquiry Practice and Procedure, Rules 2010 CI 65. So if that is there, and they say they want to now do it as a regular litigation, is that not going away from what the statute books prescribes?
But this is not a committee of inquiry. This is not a committee of inquiry, as provided by the Constitution. This is a committee established under Article 146 of the Constitution, and not any other provision of the Constitution. Committee of inquiries are established under a specific provision of the Constitution.
But this is also established under a provision of the Constitution, not so?
Article 146 of the Constitution. This is a procedure under Article 146 of the Constitution, and not any other provision of the Constitution. And I'm saying that the Committee of Inquiry has been provided for in the Constitution. And the processes to invoke a Committee of Inquiry have been provided for by the Constitution. And this is not a Committee of Inquiry.
If this is not a Committee of Inquiry, what is it then?
It's a committee established pursuant to Article 146 for the removal of justices of the Superior Court of Judicature. And that's self-contained.
But what is its role? Is it not to inquire into something?
Its role is to ascertain the veracity of the matters contained in the petition by citizens of this country who have reason to believe that a justice of the Superior Court of Judicature has brought herself or himself within the ambit of Article 146(1) of the Constitution.
But is that the same as a regular litigation hearing in court?
So the procedure has not been provided under Article 146 of the Constitution. And the committee established under Article 146 has decided to adopt a procedure that is known to everybody.
If that is the case, is it normal practice then that the committee says the petitioners will conduct their case as they deem fit without presenting a petition to the committee or testifying on oath? I mean, that they can just come and make their case, but not to testify. Is that a normal practice?
Well, this is what the Chief Justice is saying, or the suspended Chief Justice is saying. And I'm minded as a lawyer to uphold the tenets of the Constitution, which says that everything that happens at the committee is supposed to be in camera. And so I will not be able to comment on what she is saying. The fact is, everything surrounding what happens at the committee level ought to be in camera.
But if it's in camera and she feels that that is being used against her, doesn't she have the right to come out like she's done?
She should go to court. It is a committee established under Article 146 of the Constitution. And she thinks that the committee is not following the procedure provided for under Article 146 of the Constitution. Her recourse is to court, not to a press conference.
Okay. Grateful to you. Let me bring in Frank Davis. He's chairman, Constitutional and Legal Committee of the MPP. I'm grateful to you, sir, for joining. Many people have argued that she should just let the case be tried in court and that's it. What are your views?
Thank you very much. A good evening to your esteemed listeners and cherished listeners. What did you say? You should let the case be tried in court. I don't understand what you just said. What did you just say?
The argument that people put across is that she should allow the committee one to go into the issue. If she has an issue, she should just go to court and not to be coming out to the public as she's done.
Well, the Article 146 proceedings, I do not think by any stretch takes away the fundamental human rights of the Lady Chief Justice. I don't want to believe that because it is an Article 146 proceeding, if she goes there and she's being strangled, if somebody holds her by the neck, because it's an in-camera proceeding, she can't come out and come and say that somebody held me by the neck. Let's stop this simplistic attitude to what is going on. All right? She has rights which are embedded in the Constitution. Those rights can never, ever be taken away from her by any Article 146 proceeding. And let me address what my very good friend Inusa just said. And I'm sorry, but for the first time, I could see Inusa struggling. You see, an Article 146 proceeding, as he is saying, is unveiled. Justices of the Superior Court of Judicature have gone through similar processes for their removal. We know how those proceedings are conducted. Well, I cannot speak, like my good friend said, and I'll go a leaf from what he said. I cannot speak to other matters which have arisen out of the committee proceedings because I have not been party to those proceedings. But on the surface, on the threshold, what she has said, I don't know what rules, practices, and procedure is being adopted there. But how can we all be told, at least Husseini has not digressed from that, how can we be told that process has been reduced to an ordinary litigation? It is baffling. How can a petition which has been lodged against a lady sitting Chief Justice for a removal, how can that process be turned into a litigation, an ordinary litigation? Why didn't they sue her in court then? Why didn't they mount the action as plaintiffs? And then she will be defendant. How can those proceedings be constituted into an ordinary litigation, even if it is not a committee of inquiry, committee of inquiry? It is akin to a committee of inquiry. So if there are no enabling processes or proceedings for their sit, they can adopt proceedings which are known for this kind of proceedings. So, I don't think that we should be taking these things just on the face of it. These are matters which go to the very heart of our constitutional democracy. This is a Chief Justice, the third arm of government. She is the head and the front of justice. She is the head of the judiciary, a separate and independent institution from the legislature and the executive. If there is something against her, fine. Nobody is quarreling against the fact that petitions have been brought against her. She cannot stop people from bringing petitions against her. But it should be fair. Reasonableness should be attached to the proceedings, and a tinge of conscience. It should be conscionable. So how can anybody tell me that a petition for the removal of a sitting Chief Justice has been constituted into an ordinary litigation. You were asking him. Now, if there are no lay down proceedings to government, I want to believe that those who constituted that committee would have also tried to give the roadmap for how the proceedings there are conducted.
Okay. I'm grateful to you, Lawyer Frank Davis, for joining us here. He is chairman of the Constitutional and Legal Committee of the MPP. Earlier, you heard me speak to Inus Afuseni. He's a lawyer and former roads minister. There's more on this particular story coming up on Newsnight.